Hello, everybody, and thank you for joining us for our seminar today. As you can see, the title of the seminar is Bid Rigging, Cartel Regulation and Public Procurement Law, a comparative perspective from Switzerland. My name's Rebecca Wallace, and I'm a co-convener of the seminar series for this seminar, which is called Let's Talk About Corporations, and it's a joint initiative of the Sydney Law School and the TC Byrne School of Law here at UQ. I acknowledge the traditional custodians of the lands on which we all meet, and for us here at UQ, that's the Jugara and Turrbal people, and I pay my respects to elders past and present. We're really happy to welcome our speakers here today, particularly our key speaker, Leandra DM. So Leandra is joining us as a visiting research scholar here at UQ for the time being, and she comes from the University of Lucerne in Switzerland. As a discussant, we also welcome Dr. Barbara Jedlikova, who is one of my colleagues here at the law school and really has expansive and great expertise in competition law. So her words are going to be really valuable to us at the end of the session. The session's listed for about an hour. Leandra's going to talk first for a while about the key issues for today. And then I'm going to invite Barbara to speak. And if you have questions along the way, please do pop them into the Q&A chat box, and we can kind of collect those towards the end of the seminar and pose them to the speakers to answer. I'll also give you an opportunity at the end to remind you to do that if you would like to ask them questions. So without further ado, Leandra, I'd like to welcome you, and please let us know what you would like to say.
Thank you very much, Rebecca, for welcoming me here as a guest speaker from Switzerland to talk about the topic of bid rigging and its prosecution under Swiss law. In my presentation, I will begin with a short introduction in bid rigging. Then I will come to the core of my presentation, which is the legal framework in Switzerland for the prosecution and sanctioning of bid rigging. In Switzerland, bid rigging can mainly be prosecuted in two ways. Firstly, by means of cartel law, and secondly, by means of public procurement law. After an overview of the cartel law approach and the public procurement law approach, I will conclude my presentation by briefly discussing the interplay between these two approaches. The term bid rigging is commonly used to describe the practice wherein entities interested in public contract agree on who gets the public contract and at what price. To illustrate bid rigging, I want to give you some recent examples of bid rigging cases in Switzerland. Probably the biggest scandal in connection with bid rigging in Switzerland took place in the southeast of Switzerland in the construction work area. In the years 2004 to 2012, 40 undertakings from the sector of building construction, civil engineering, and road and surfacing works agreed on which of them should receive which public contract and at what price. The other companies subsequently offered their services at higher prices or refrained from submitting a bid. A total of over 1,000 construction projects were affected. For reasons of procedural economy, the competition authorities investigated these agreements in 10 different proceedings. The last two proceedings were concluded in 2019. And then, after assuming that this chapter was closed, the competition authorities came across renewed indications of further bid rigging in this context. So they opened the 11th investigation in mid-2022. Also in 2022, the competition authorities opened a similar investigation into possible agreements in the context of public tenders for road rehabilitations. In particular, the Competition Commission has received information on alleged bidding agreements made by 4 companies from 4 different French-speaking cantons. It is suspected that these companies coordinate their offers and prices for several years in the context of public procurement procedures. In 2022 again, the competition authorities closed an investigation concerning bid rigging in the car dealership sector in the Italian-speaking part of Switzerland, which is in the south of the country. Various car dealers of Volkswagen Group brands had agreed between 2006 and 2018 to restrict competition between dealers of Volkswagen Group brands, and in this way to keep prices high for new cars sold to private or public customers. The cartel was also included cooperation in public procurement procedures. The purpose of the cooperation in the field of public procurement was to distribute the vehicles put out to tender or the profits from the awards among the participating undertakings. And for this purpose, they had different approaches. In one form of cooperation, the undertakings involved agreed that only one of them alone would participate in the public tenders. They then shared the profits from the contracts among themselves. In another form of cooperation, they agreed that one company would forward its offer for the public tender to each of the other participating companies. The others then submitted either a more advantageous or a less attractive bid in terms of price, depending on the content of the agreement. The companies sometimes also divided the territories among themselves and agreed that they would refrain from participating in public tenders outside their respective areas of responsibility. The last case that I want to present, also a case of bid rigging. This one concerned the market of optical networks. Optical networks are fiber-based telecommunication networks that allow data communication between two or more locations. And in this case, the public contracting authority, it was the Switzerland's National Bank, based in Bern, this time in the German-speaking part of Switzerland, wanted to purchase such optical networks on the free market and therefore asked one provider for an offer. For comparative reasons, the National Bank invited two other suppliers to submit an offer. Subsequently, all the invited bidders, including the manufacturer of the existing infrastructure, then agreed that the two other invited bidders would submit a protective bid so that the first invited bidder would be awarded the contract. To implement this agreement, the first bidder disclosed its retail discount to ensure that the other two did not bid lower and would therefore not submit a competitive bid to the contracting authorities. So with these examples, I wanted to show you that bid rigging occurs in Switzerland regardless of the professional sector, the geographic area, and the language spoken, and that bid rigging is actually a current concern. So the concern of bid rigging is that when the entities interested in a public contract enter into bidding agreements, it results in a mere illusion of competition within the public procurement market concerned. Bid rigging then raises prices, can go hand in hand with lower quality of goods and services, and makes undertakings inefficient and discourages innovation. They therefore have a negative impact on the economy and the public sector. So, and with these words, I would like to move on to the legal framework in Switzerland. In Switzerland, the Swiss Federal Constitution obliges the Confederation to enact regulations against economically or socially harmful effects of cartels and other restraints on competition. The implementation of the so-called cartel article, and therefore the prosecution of cartels and other restraints on competition, is primarily carried out through antitrust legislation in the Cartel Act. In addition to antitrust law, the public procurement decrees of Switzerland also contain provisions on the prosecution of bid rigging, even if the procurement decrees are not directly based on this cartel article. So I start with the Cartel Act. The purpose of the Cartel Act is to prevent the harmful economic or social effects of cartels and other restraints of competition, and by doing so to promote competition in the interest of a liberal market economy. The object of the Cartel Act is therefore the protection of competition in Switzerland against certain private law interventions. The protection of competition is based on 3 pillars: the prohibition of cartels, the abuse control, and the merger control. The prosecution of bid rigging falls under the first of the 3 pillars, the prohibition of cartels. The prohibition of cartels is stipulated in Article 4, Paragraph 1 and Article 5 of the Cartel Act. In its Article 4, Paragraph 1, the Cartel Act defines the concept of an agreement affecting competition. According to this article, agreements affecting competition are binding or non-binding agreements and concerted practices between undertakings which have a restraint of competition as their object or effect. The provision contains 3 elements that must be fulfilled. Firstly, 2 or more undertakings must be involved. Secondly, these companies need to coordinate their conduct. And thirdly, the coordination of conduct must have a restriction of competition as its object or effect. Generally, the entity's status is inherent to the tenders participating in bid rigging. By submitting an offer, the tender constitutes itself as an independent participant in the public procurement market. This also applies to companies that agree not to participate in a public procurement procedure as part of the agreement. The aim of the companies involved in bid rigging is usually to coordinate their bidding behavior with regard to 1 or more public procurement procedures. Such coordination requires a minimum degree of coordination and can therefore usually be covered by the criterion of coordination of conduct. In a bid rigging agreement, the parties to the agreement usually agree who among them may submit a bid at all and or what the content of the bids to be submitted should be. Such an agreement generally has at least the object of restricting competition between the companies involved in the agreement. So consequently, bid rigging usually is qualified as an agreement affecting competition in the sense of the Cartel Act. Article 5, Paragraph 1 then specifies when an agreement affecting competition is unlawful. This is the case if the agreement significantly restricts competition in a market for specific goods or services and is not justified on grounds of economic efficiency, or if the agreement eliminates effective competition. So the Swiss Cartel Act makes a distinction between 2 types of unlawful agreements affecting competition. Firstly, agreements that significantly restrict competition in a market and that cannot be justified on grounds of economic efficiency. And secondly, agreements that eliminate effective competition. Those agreements, the elimination ones, they cannot be justified on grounds of economic reasons. The Cartel Act presumes the elimination of competition in certain situations, referred to as presumptive cases. Those cases are listed in Article 5 as well in the paragraphs 3 and 4. Paragraph 3 refers to horizontal agreements and paragraph 4 to vertical agreements. Since bid rigging is usually a horizontal agreement, we will only have a look at paragraph 3. So according to this paragraph, horizontal agreements are presumed to eliminate effective competition when they involve the direct or indirect fixing of prices, so-called price agreements, the restriction of production, purchase, or delivery quantities, so-called quantity agreements, or the allocation of markets by regions or business partners, so-called territory agreements. The subject of bid rigging is usually the final price or individual price components of the offer. So bid rigging aimed at influencing the price formation can generally be qualified as a price agreement. And if the parties to the agreement agree on who is to be awarded the contract in which tender, this is usually a territory agreement. So accordingly, bid rigging usually fulfills one of the presumptive cases of the Cartel Act. It is therefore presumed that they eliminate effective competition and are unlawful. However, the presumption of eliminating competition can be rebutted by demonstrating the existence of effective remaining competition. But if the presumption is successfully rebutted, the corresponding behaviors are still considered as significant. And significant restriction, as I said, they are only unlawful if they cannot be justified for reasons of economic efficiency. But this is, in the case of bid rigging, almost never possible. So this means that bid rigging is generally unlawful under antitrust law. The enforcement of the cartel prohibition primarily falls under the responsibility of the competition authorities, composed of the Competition Commission and its Secretariat. To assess whether a violation of the cartel prohibition has occurred, the competition authorities can initiate either preliminary investigations or investigations. And then if the competition authorities determine that the bid rigging agreement constitutes an unlawful agreement affecting competition, the Cartel Act provides for various legal consequences. Firstly, under certain circumstances, the Competition Commission can impose a sanction. More precisely, the Competition Commission can pronounce a sanction under cartel law if it comes to the conclusion that the bid rigging in question has been proven and fulfills the criteria of one of the presumptive cases. Then the sanction is up to 10% of the turnover achieved in Switzerland in the last 3 years. Depending on the turnover of the company in the market affected by the infringement, sanctions can be very high. For example, the highest individual sanction that has been legally enforced to date was around 160 million Swiss francs, which is equivalent to 275 million Australian dollars. The sanctioned undertaking in this case was BMW. And in the case of the construction cartel that I mentioned in the beginning, 12 undertakings were sanctioned with a total of 11 million Swiss francs, which is about 19 million Australian dollars. And lastly, the undertakings in the procedure concerning the car dealership sector overall had to pay 44 million Swiss francs, which is about 75 million Australian dollars. The system of direct sanctions in Switzerland consists not only of the sanctions, but also of a leniency program. According to this program, the Competition Commission waives sanctions in whole or in part if companies uncover restraints of competition or cooperate in their elimination. A full waiver of the sanction is granted to the company that first notifies its involvement in a restriction of competition and provides information that enables the opening of an investigation, or provides evidence that makes it possible to establish the infringement. The leniency program is intended to provide an incentive for the companies involved to detect cartels and therefore increase the likelihood of cartels being detected, as well as to simplify the work of the competition authority. If not all conditions for a full waiver of the sanctions are fulfilled, a reduction of the sanction is nevertheless possible. Such a reduction requires that an undertaking has cooperated in proceedings without being asked to do so, and has ceased to participate in the competition infringement in question at the time the evidence is submitted. The amount of the reduction is then up to 50% of the sanction. In the optical networks case, for example, 2 leniency applications were filed. The first leniency application was filed before the opening of the investigation. And although the Secretariat was already aware of a possible bid rigging agreement at that time, the leniency application made it possible to open the procedure. This company was therefore granted full waiver of sanctions. And the second leniency application enabled the competition authority to establish the competition violation together with the existing evidence. And due to this, the sanction of the second undertaking was reduced by 50%. Instead, or in addition to a direct sanction, the competition authorities may also order so-called appropriate measures, as it is written in the Cartel Act. With these appropriate measures, the companies are obliged to perform or refrain from a certain action. And finally, if the Secretariat considers that a restraint of competition is unlawful, it may propose a so-called amicable settlement to the undertakings involved concerning ways to eliminate the restraint. The conclusion of an amicable settlement serves to settle an investigation as quickly and simply as possible. On the part of the competition authorities, an amicable settlement requires that they have opened an investigation due to indications of an unlawful agreement affecting competition. On the part of the companies, an amicable settlement presupposes a willingness to voluntarily take measures to remove the restriction of competition, to cooperate with the Secretariat, and to forego extensive filings and an appeal procedure in order to ensure a quick conclusion of the procedure. So by signing an amicable agreement, companies voluntarily commit to adjusting their behavior in the form of commitments. That's why orders with an amicable settlement are likely to be perceived more positively by the public. Another advantage of an amicable settlement from the point of view of the undertakings concerned is that the violation of the Cartel Act of which they are accused of are not presented in full detail. The conclusion has also an impact on the amount of the sanction. If the undertakings conclude such an agreement, the competition authority will award this with a reduction of the sanction. The earlier in the procedure an amicable settlement is reached, the higher the sanction reduction. If a settlement is reached at an early stage, the sanction can be reduced by up to 20%. The legal institution of the amicable settlement is of relatively great importance in Switzerland. The majority of investigations by the competition authorities are concluded with an amicable settlement. So in the presented case of optical networks, for example, the competition authorities have reached an amicable settlement with all parties. And also in the car dealership investigation, 5 out of 7 companies agreed to settle the case amicably. Bid rigging can not only be prosecuted and sanctioned by the competition authorities, but also by Swiss public procurement law. Public procurement law in Switzerland is regulated on 2 levels. On the one hand, at the federal level in the Federal Act on Public Procurement, and on the other hand, at the cantonal level. The cantons of Switzerland have each their own public procurement decrees. In addition, they have jointly adopted an intercantonal agreement on public procurement to harmonize public procurement law at the cantonal level. And however, as part of the recent total revision of the procurement law, Swiss public procurement law was largely harmonized at all levels, which means that most of the provisions are now identical. The purpose of the Swiss public procurement law is, among others, to ensure the promotion of effective fair competition among tenders, in particular by means of measures against unlawful agreements affecting competition. In contrast to the antitrust law, the public procurement decrees do not contain a legal definition of the term unlawful agreements affecting competition. However, in practice, jurisprudence, and doctrine, the prevailing view is that the term unlawful agreement affecting competition implicitly refers to the Cartel Act, which defines what constitutes an unlawful agreement affecting competition. So I'm not going into more details here, but I refer to these statements. The inclusion in the purpose statement underscores the high significance of pursuing bid rigging in public procurement law. Of central importance for achieving this purpose of that article is the procedural principle as per Article 11, letter B, which obliges public contracting authorities to take measures against unlawful agreements affecting competition. However, specific measures that public contracting authorities must take against unlawful agreements affecting competition are not explicitly outlined in Article 11 itself, but the revised procurement regulations to contain isolated provision that specify those measures. In particular, according to Article 26, The contracting authority must ensure, both during the award procedure and the execution of the contract, that the tender and its subcontractors fulfill the participation conditions. This includes refraining from entering into any unlawful agreement affecting competition. To fulfill this requirement, public contracting authorities can request tenders to demonstrate compliance with the participation requirements, notably through self-declarations. From the tender's perspective, refraining from entering into any unlawful agreements affecting competition, it is a fundamental requirement in public procurement law. It is a condition for them to participate in a public procurement procedure at all. So if a tenderer engages in unlawful agreements affecting competition during a procurement process, it is not allowed to participate in the award procedure. Swiss public procurement law provides the contracting authorities with a wide range of instruments to take legal steps against bidders who take part in bid rigging. If the tenders violate the prohibition of participating in unlawful agreements affecting competition, it is a duty of the public contracting authority to take the necessary measures. Those measures can be divided into two categories. So the first category includes measures, and the second category encompasses sanctions. As measures, the contracting authorities may exclude the tender from the ongoing award procedure, revoke the award, or under certain circumstances, abandon the award proceeding. These measures serve to restore the lawful state in the award proceedings. And since the measures normally have to be taken quickly in order not to delay the award procedure for too long, and since there are no coercive measures available to the public contracting authorities, the standard of proof for pronouncing a measure has been lowered. So namely, it is enough if there are sufficient indications of bid rigging in order to impose a measure. If all the tenders involved in the award procedure have participated in the bidding agreement, then the contracting authority is permitted to award the public contract in question in the direct award procedure after the procedure has been abandoned. So that means directly and without conducting a new public invitation to tender. In contrast to the measures, the sanctions are aimed at sanctioning the offending bidders for participating in the bidding agreement and discouraging them from participating in further agreements. Furthermore, they are only permissible if it constitutes a serious violating. And if there is a case of a serious violating, the contracting authorities at the federal and the cantonal level can warn an offending tenderer or exclude it from future public contracts for a period of up to 5 years, so-called award ban. At the cantonal level, the contracting authorities can additionally sanction the offending bidders with a fine of up to 10% of the adjusted bid amount. The legally binding exclusion is recorded in a non-public list of sanctioned tenders and subcontractors, which records the reasons for the exclusion and the duration of the exclusion from public contracts. While the measures can only be imposed during the ongoing award procedure, the sanctions can also be imposed after the conclusion of the procedure. The time pressure for pronouncing a sanction is therefore lower than in connection with a measure. And for this reason, and because of the more drastic consequences for the tenderers concerned, the standard of proof for the pronouncement of a sanction is higher. So namely, full proof is required here. In addition to the measures and the sanctions, the procurement decree stipulates that in any case, the contracting authority has to notify the Competition Commission of any suspicion of unlawful agreements affecting competition. So we have now seen that one and the same bid rigging agreement can be pursued and sanctioned with antitrust and with procurement law measures. So the question now arises about the relationship between these two procedures and sanctions. Regarding the relationship between antitrust sanctions and public procurement law measures, The Competition Commission has long held that a bid rigging agreement could be the subject of both a procurement law and an antitrust procedure. If a situation satisfies one of the legal conditions of the Cartel Act and the Public Procurement Act, both laws can be applied concurrently in terms of sanctioning the bid rigging agreement. According to the Competition Commission, this is primarily because public procurement law and antitrust law protect different legal interests. Procurement law is aimed at protecting the interests of the public contracting authority, who has to use public funds economically, while it falls into the responsibility of the competition authorities to enforce effective competition. The coexistence of antitrust sanctions and procurement law measures can also be justified due to the distinct nature of these two measures. Procurement law measures aim to restore the lawful state in the procurement process, regardless of any potential wrongdoing by the bidders. The primary goal is not to punish the tenderer for their behavior. In contrast, antitrust sanctions specifically aim to penalize certain conduct by the bidders. These antitrust sanctions are both punitive and preventive in nature, and consequently, they require a wrongdoing on the part of the tenderer. So since the sanctions are complementary, they can be pronounced simultaneously. The situation becomes more complex when there is a coexistence of antitrust sanction procedure and public procurement law sanction procedure. The complexity fundamentally arises from the principle of nebis in idem, a guarantee that is granted by the European Convention on Human Rights in its Article 6 to every person charged with a criminal offense. The principle of nebis in idem, or also known as double jeopardy, prohibits a renewed prosecution for the same cause of action. The principle is violated if the same person is judged or punished twice for the same or essentially the same behavior in two independent criminal proceedings, provided that the first judgment has already become final. So, as we have seen before, the Competition Commission and the contracting authorities can both prosecute one and the same bidder for taking part in one and the same bid rigging agreement. And if the conditions of the sanctions are fulfilled, they can also sanction the same person for the same behavior. So we have the same person and the same facts. And against this background now, the central question is if both sanction proceedings are qualified as criminal within the meaning of Article 6 of the European Convention. According to the European Court of Human Rights, a sanction proceeding is considered criminal if either domestic law classifies an offense as criminal, or if the nature of the offense and or the severity of the penalty speaks for the criminal character of the charge. Regarding the antitrust sanctions, there is a clear jurisprudence that the antitrust sanction proceedings qualify as criminal charges within the meaning of the Convention. Regarding the sanctions under public procurement law, there was recently a judgment of the Swiss Supreme Court that stated that at least the fine under public procurement law qualifies due to its severity as a criminal charge within the meaning of Article 6 as well. In view of the possible amount of the fine under public procurement law, which is unlimited upwards and may well reach millions, the fines under public procurement law can have a drastic financial impact on the tenderer concerned, which can be even an existential threat. This justifies to qualify the fine under public procurement law as criminal. Regarding the award ban, there has not been a judgment on the question of their criminal character yet. However, the doctrine tends to take the view that the award ban cannot be qualified as criminal in the sense of the Convention. So, while the fine under public procurement law has a criminal character within the meaning of the Convention, this might be denied for the award ban. And this conclusion leads us now to different results at the federal and the intercantonal level, because the fine under public procurement law is only provided by the intercantonal agreement and not in federal public procurement law. So since federal public procurement law does not provide for a fine, the sanctioning procedure under public procurement law at the federal level, therefore most likely does not constitute a criminal charge within the meaning of the European Convention. In contrast, the sanction procedure under public procurement law at the intercantonal level is to be qualified as a criminal charge due to the threat of a fine. So, but which consequences as is now on the principle of nebis in idem? As a consequence of a full applicability of the nebis in idem principle in public procurement sanction proceedings, a contracting authority at the cantonal level could not further judge and punish the offending tenders if there is already a legally binding judgment of the Competition Commission concerning the same bid rigging agreement, and reversely. So if, for example, a tender has already been sanctioned under cartel law for participating in an unlawful agreement, the cantonal contracting authority will no longer be allowed to fine the tenderer for the same behavior. On the other hand, since the sanctioning procedures at the federal level are not considered as criminal charges within the meaning of the convention, a tenderer who has participated in bid rigging may at the same time be sanctioned under antitrust law and excluded from future public contract under public procurement law. So regardless of which procurement law decree is applicable, the competition authorities and the public contracting authorities are still bound by the principle of proportionality when prosecuting and sanctioning bidders who participate in bidding agreements. This requires at least that all the cumulative sanctions and measures are in reasonable proportion to the severity of the particular bidding agreement. So therefore, if a measure or a sanction has already been pronounced by one authority, the second authority must take this circumstance into account when pronouncing the second sanction. And this brings me now to the end of my presentation, and I am happy to pass on my words to Barbara.
Thank you, Landra. I'm just going to start my video. Yes. Thank you so much, Landra. This has been really interesting perspective from Switzerland. I just remember when I got your first email about your interest here to undertake part of your research in Australia, and you sent me your topic and description of your research, and it was competition law and public procurement law, and I thought, yes, it makes sense to me. However, it might be quite interesting journey for you to come here and do this short, let's say, stay and research in Australia. And at the same time, I thought, well, this is definitely an important topic we need to discuss. And so, why I'm saying that, my first degree is from Czech Republic, and I have my master's in law and legal studies from Czech. So that's why it hasn't been a surprise to me that you combining the procurement law and competition law, that there is this overlap. Because if we have a look, for instance, that's just to kind of make a little point. It's going to take me a bit of time. I'm going to share some websites. So if you look at just briefly, hopefully you can see this website. Yes. Okay. So this is a Czech competition authority, and if you look at their website in English, so the English translation, you can see straight away at the beginning. So the competition authority deals with competition. The description is it's a central authority of state administration responsible for creating conditions that favor and protect competition, supervision over public procurement, and consultation and monitoring in relation to the provision of state aid. State aid obviously is under a different era under European Union, which comes from the European Union regime, and we have it as members of the European Union. But the public procurement and competition law, this overlap has been there since the beginning. So the thinking about competition law, public tenders, and seeing the public tenders and seeing the overlap in the form of bid rigging has been there. Now, when we look at, and again, it's going to take me a little bit of time, if you look at different websites, sorry, no, not this one, this one. So if you look at the ICCC's website, and if you want to find something about procurement, public procurement law, obviously, in connection with bid rigging, we wouldn't really find any information. So why I'm saying that the discussion is important, because this discussion, there's this gray area in Australia when we actually don't have discussion about the overlap between public procurement law and competition law. And it would be definitely useful, as we can see from the Swiss approach, to have, and it's not, I wanted to make that point from Czech Republic just to kind of highlight that Swiss approach is not the only approach where Switzerland kind of think about public procurement and competition law and thinks about this overlap. And it's kind of incorporated in the regime. You would find it in other civil law jurisdictions in Europe, at least, as well. But in Australia, as in other regimes, I would say common law regimes, we kind of miss this discussion on public procurement law and competition law, bid rigging. At the same time, obviously, the bid rigging is very important in Australia, or anti-bid rigging law, because it's part of the cartel, anti-cartel protection law regime. So we have a new, or not so new, but it's quite recently, we had the introduction of the new, relatively new, not so new anymore, regime in Division 1, Part 4, sections 45AA to section 45AU, where we know that bid rigging is one of the forms which is per se prohibited in Australia. And we have quite recently a new bid rigging case, which is private enforcement case. So Swiss network has to pay now 1.2 million in penalties, which again we can, from Switzerland approach, kind of compare, although we would have to dig in details, but we can compare the range of penalties here in Australia and in Switzerland. And again, this is actually something which we have been debating in Australia for quite a long time, whether for instance, the penalties are significant enough to deter potential participants, cartel participants. So that's all important. And in that sense, when I said at the beginning that Landra might be quite surprised about certain things, my first question to her would be, Landra, I know it's been only a short period of time you've been here, but have you been surprised about the Australian, let's say, anti-bid rigging area of law? And if yes, what has been the most surprising for you so far?
So, okay, I think now you can hear me.
Yes.
So yeah, it's a really good question. And I was really surprised. So what surprised me has a close connection to what you just said about the legislator in Australia. So I think what surprised me most weren't the decisions taken here, but the legislation. So I saw that the Australian Competition and Consumer Act contains very detailed provisions under what circumstances a cartel is unlawful. And as you said, it even stated that bid rigging is a form of cartel that is unlawful. So the Act refers directly to public procurement law and says that, yeah, bid rigging is actually a concern, it's unlawful. But then at the same time, I was looking at the public procurement degrees and I couldn't find any provision on bid rigging. So yeah, that surprised me kind of, because in Switzerland, for example, bid rigging is not explicitly stipulated in the Cartel Act. But our practice is that bid rigging is generally presumed to be unlawful. yeah, so that was really surprising to me. And then there was something else actually that surprised me, that I found these guidelines for contracting authorities on how they should behave when they have indications on bid rigging. So there is actually something, but then all I could find, like if I understood this correctly, is that when they have indications or a suspicion on bid rigging, they can just notify the Competition and Consumer Commission, but it doesn't affect the public procurement procedure. So again, like they see, okay, it's a problem, we have to do something, but it doesn't affect. So for example, in Switzerland, we have to like exclude the tenders or do something. And yeah, it's just different, and this surprised me. Yeah. And yeah, so when I can just like have a follow-up question here, you said it is a big concern. It is, you're talking about this. So in your opinion, do you think like the measures that Australian law has against bid rigging are not sufficient, or are they sufficient?
Yeah, thank you, Landra. I mean, generally, of course, it's Competition and Consumer Act which would apply to this. And in that sense, obviously, if we're talking this private and public enforcement, but the ACCC would be most likely the one taking such a case. So we do have definitely a law dealing with this, most in kind of typical scenarios, like the scenarios which you, or the cases which you actually discussed with us today. Those would be kind of cases which, if those happen here in Australia, we can apply the competition law under the Competition and Consumer Act. They might be potentially, when we talk about public procurement law, certain situation when perhaps the Competition and Consumer Act wouldn't apply. But generally, like if I think about the general typical scenario, we have a public tender, and competitors, usually private corporations, might be not only private corporations, they might bid for such tender. That would be competition law, Australian competition law, which would apply. But what's really interesting, I mean, I started, yeah, we don't really have this discussion here in Australia. I think it's a very important discussion to have. Also, the federal government is undertaking now a review of competition policy. It would be nice to include this overlap, public procurement and competition law. But we don't. I couldn't definitely since the new regime, although we still have Section 45, but definitely since the new regime, I can't. I mean, the first case which was testing that anti-cartel new regime law, if you want, it's not so new, was also on bid rigging, Norcast, Broadcom, but it was a private enforcement. Again, we are in private sector. I can't find any really public tender examples in Australia. It might be in a deep history that perhaps some example exists, but definitely not in the recent time. We don't have anything in comparison to Swiss law, let's say, and enforcement. We can see that there are some really good examples. You can also see that the penalties, and there's a difference, if I understand it correctly, please correct me, Landra. There is quite a big difference between competition law or penalties awarded under competition law and penalties awarded under that public procurement law. But if it's awarded under the competition law, they are quite significant. We tend to think that, like the most recent case, the Swiss networks 1.2 million is quite significant. And as I said, there have been discussions about ongoing discussions about whether this is significant enough to deter, and in comparison with other jurisdictions. And you can see, like Swiss, experts who would argue they are not significant enough, we should increase them. That just supports that argument. And obviously there are other types of remedies. So in theory, we do have way how to deal with it, obviously, but we just don't have any examples or recent examples. And I think it would be naive to think those examples don't exist because this never ever doesn't happen here. I'm quite pessimistic in that way. So yeah, I think, you know, the other issues embodied in that, and definitely starting to have been more discussion about public procurement and competition law, the overlap, specifically in the form of anti-bid rigging law, so anti-cartels form of bid rigging, is very, very important to have here in Australia. Another thing, like obviously there were several things I have been thinking of when listening to Leandra. From that comparative perspective, I did notice that competition law is very significant, and significant to the sense that you even have an article in Swiss constitution which deals, although it's called cartel article, but obviously from the wording, it's obvious that it includes not just cartels, but also other anti-competitive practices. To have that actually in constitution is something which really, I find it really interesting that it is in constitution. And I was wondering whether you might have any comment or thoughts about that. Obviously, we don't have anything like that in Australia, or other jurisdictions don't have anything, any specific provision in constitution itself, which would deal with competition law so directly.
Yeah. So I think in Switzerland, like, you have to understand that the federal legislator can only take action if it's authorized to do so by the federal constitution. So there is a constitutional basis needed for a national law. So without a constitutional provision, there cannot be a federal law. So that's like already, yeah, it's the ground for everything. And well, maybe about a little bit of history. So there was long no legal regulation of cartels in Switzerland, although, or maybe also perhaps, cartels were widespread, and they were also accepted in large part of economic life. So in the year 1900, the cartels were part of the everyday economic life. And I can maybe give you an example. So in the year 1893, there was a cartel composed of bakers. And according to this cartel, the master bakers were obliged to buy the flour only from those millers who were also members of the cartel. And conversely, the millers were forbidden to sell flour to a master baker who was excluded from this cartel. And then this cartel came into a conflict with a master baker because this one was selling the flour at a price that was of his own choosing. And then the Federal Supreme Court held that that it's not unlawful to build a cartel, and it's also not unlawful to impose a minimum price on its members at which they could sell the flour. So I think like there was the society that saw that cartels are lawful. So there was no mean for a cartel article, of course. But then after the First World War, there was the number of cartels increased, and mainly also because of the economic crisis. And so at this time, economic security seemed more important to everyone than the possibility of being able to develop freely in competition. But since the number of cartels raised, there were also voices that wanted to put a stop on these business practices. And so by time it was, I think, 1920s, there were a lot of parliamentary initiatives that have been taken to take measures against those cartels. And so, yeah, I think on this grounds, there was a draft then for this cartel provision in the constitution. I think it was it was before the First World War and the Second World War, sorry, and it was a bit delayed then to how can I say, there was a delay because of the Second World War, but after this, the article provision, they put the Cartel Act, cartel provision in the Constitution. And I think it was also because of the pressure, because in the United States, they started to have a comprehensive competition law, and also the European Economic Community were creating a competition law. So it was a change of thinking, and then they changed the Constitution.
Thank you, Yolanda. I think we are running out of time, so I will pass it to Rebecca.
Thanks very much. We do have just a few moments for anybody to post any last questions or comments in the chat box. I do note that there was one posted to point or direct us to the ACCC's guidance around public or government procurement professionals and an outreach program that they run. So I think that was kind of also noted, that there is a framework for that kind of for that issue to be at least advised upon or directed to the ACCC. But otherwise, I would just really like to thank you both for joining us today, and I hope that that was of interest to our audience. I think it's always really interesting to see comparative perspectives and to see what works well and differently, and to kind of, I guess, stimulate our imagination about where changes could be made and where we can draw from practice in other jurisdictions, look outside our own island occasionally. So thank you very much for both of your insights, and thank you very much for joining us, everybody.
Thank you, Rebecca.
Oh, sorry, I do have one quick question that's just come in late. Heard bits and pieces of what you're saying regarding part of a legislation in relation to bid rigging law. Could you repeat what act that is and what the relevant sections are? What we can do is make the we are making the slides, the presentation available, and so it might be that might be really easy then to review that way in response to that question. Thank you. Thank you very much, everybody, and hopefully you'll join us for our next session in this seminar series is on the 8th of November, and it's around monetary sanctions and in corporate contexts. So please join us for that. Keep your eye out for the material that'll come for registration soon. Thank you.